Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today's video explains the 16th stage of a civil case, the execution of decree. This stage becomes important when the court has already passed a judgment, but the opposite party does not comply with it. Execution ensures that the winning party actually receives the benefit of the judgment. What is execution of a decree? Under Section 36 of the Code of Civil Procedure, 1908, execution refers to the entire process through which a decree holder enforces the decree passed in their favor. In simple words, receiving a judgment is not enough, its implementation is equally important. Types of decrees that can be executed. Execution can be initiated for several kinds of decrees. These include 1. Money decree. 2. Decree for possession of property. 3. Decree involving injunction or specific performance. 4. Consent decree, and even final decree. Each type has its own method of enforcement, but they are all covered under the execution provisions of the CPC. Important legal provisions. Execution proceedings are mainly governed by Order 21 of the CPC, which contains the detailed rules for enforcing a decree. In addition, Section 47 of the CPC states that any question or dispute arising during execution must be decided by the same court which passed the decree. Under the Limitation Act, 1963, a decree must be executed within a period of 12 years. Further, the CPC Amendment Rules, 2023 introduce modern features such as e-filing and digital execution processes. Procedure for execution of a decree. Step 1. Filing of execution petition. Execution begins when the decree holder files an execution petition in the court that passed the decree. The petition must include a certified copy of the decree, an affidavit stating that the decree has not been complied with, and a clear statement of the relief or action sought from the court. Step 2. Notice to judgment debtor. A notice is issued to the judgment debtor when more than 2 years have passed since the decree was passed, or when the execution application is filed in a court different from the original court. This requirement arises from Order 21 Rule 22 of the CPC. Step 3. Objections and hearing. The judgment debtor has the right to raise objections under Section 47 of the CPC. These objections may relate to fraud, prior payment, a mistake, or any other legal reason affecting the enforceability of the decree. The court hears both parties before deciding how execution should proceed. Step 4. Modes of execution. The court may enforce the decree through several methods. These include attaching the judgment debtor's property, auctioning the attached property, ordering arrest and civil imprisonment in the case of money decrees, delivering possession of property to the decree holder, or appointing a receiver in exceptional cases. The court chooses the appropriate mode depending on the nature of the decree. Step 5. Compliance and closure. Once the decree has been fully executed, the court records compliance and formally closes the execution proceedings. Common objections raised. Common objections during execution include allegations that the decree was obtained by fraud, that the decree has already been satisfied, that an incorrect party has been impleaded, or that the original order is unclear or ambiguous. These objections must be scrutinized by the court under Section 47 of the CPC. Limitation period. As per Section 136 of the Limitation Act, 1963, a decree must be executed within 12 years from the date when it becomes enforceable. Filing after this period is not permissible. Important case laws. In Satyavati v. Rajinder Singh, 2013, the Supreme Court emphasized that a decree holder must receive the relief granted by the court. In Mohit Bhargav v. Bharat Bhushan, 2007, the court held that an executing court cannot review or reconsider the judgment itself. In Surya Dev Rai v. Ramchandar Rai, 2003, it was clarified that both parties must be given a fair opportunity of being heard during execution proceedings. Practical tips. It is advisable to file the execution petition on time and attach a clear, certified copy of the decree. Provide complete factual details and prepare yourself for potential objections from the judgment debtor. It is also helpful to regularly obtain status updates from the court to ensure that the execution progresses smoothly. Summary. Execution proceedings under Order 21 of the CPC are initiated by the decree holder against the judgment debtor. The limitation period for execution is 12 years. The decree can be enforced through several methods, such as attachment, auction, arrest, or delivery of possession. Ultimately, the purpose of execution is to ensure that the decree is effectively implemented and the decree holder receives the relief granted by the court. If you found this information useful, please like, share, subscribe, and press the bell icon so you can receive more such important legal videos in time. I assure you that I will continue to provide accurate, lawful, and research-based legal information on various topics through this channel. Your support means a lot to me, so I humbly request you to stay connected with this channel. By joining this channel, you can also receive special legal information and membership benefits. Thank you very much for watching this video. See you soon in stage 17 of our civil case series. Jai Hind, Jai Bharat.